This is part 20, and in this part we shall discuss chapter 11, dealing with acceptance and payment for honor and reference in case of need. And to understand this, we have to start right from section 108 up to section 116 of this enactment, namely the Negotiable Instrument Act of 1881, with which we are dealing at present. Now, section 108 deals with what do you mean by acceptance for honor. First of all, we will try to understand this and then try to understand after that we will take into consideration what must be the object for having such a provision in the Negotiable Instrument Act. It says, when a bill of exchange has been noted or protested. So first thing that you have to note is that this provision is only applicable as far as the bill of exchange is concerned, namely acceptance for honor. And it says, when a bill of exchange has been noted or protested for non-acceptance or for better security. Now, when bill of exchange can be dishonored for non-acceptance, and when a bill of exchange can dishonor for better security, with which we have already dealt when we have taken into consideration right from section 99 up to section 104A of this Negotiable Instrument Act. So now the first thing is that the bill of exchange has been noted or protested for non-acceptance or for better security. If that is so, any person not being a party already liable thereon. So any person who is not liable already being a party already liable thereon. So the person who is not liable with respect to the bill of exchange may. So it is for that person who wants to become an acceptor for honor, that person, what he can do, may, with the consent of the holder. So he needs consent of the holder. And what is the manner in the consent is required to be obtained of the, he will obtain the consent of the holder, and what he will do, by writing on the bill, he will write on the bill, accept the same for the honor of any party thereto. Now holder, if he is Mr. E, as we have already learned, E has got right to recover amount from any one of the prior parties. Now if it happens that the E has got bill of exchange with him which is dishonored for non-acceptance or which is dishonored for better security, in that case this holder now has a bill of exchange. What he has done, he has got it noted and protested. So now Mr. E is having a bill of exchange that has been noted or protested, maybe for non-acceptance or better security. Now in that case, if this fact is known to the person who wants to guard the interest of any one of the prior parties, then what if, for example, he wants to guard the interest of the drawer, or he wants to guard the interest of Mr. Say Mr. C, or he wants to guard the interest of Mr. D. Otherwise this matter will go to the court of law, and then when the matter goes to the court of law, naturally that will be when you talk about that the negotiable bill of exchange was dishonored, that will be harm to the reputation of an individual as far as the commercial world is concerned. So instead of that, somebody, any person, but who, what is the qualification? Any person not being a party already liable. So who are the parties who are liable? A gives a direction to the drawing to carry out payment accordingly, and that is given to Mr. B, B has passed it on to C, C to Mr. D, and D to Mr. E. Under these circumstances, the parties who are liable, what is the right of Mr. E? E has got right to recover amount from prior party. So no prior party. Any person not being a party already liable there on me with the consent of the holder. So if he is Mr. Z, what Z can do? Z with the consent of the holder, he by writing on the bill, he will write on the bill and accept the same for the honor of any party thereto. So he honors such person, Mr. Z, who has accepted it. He will make mention as to the person for whose honor he is accepting. He can accept it for the honor of any one of the prior parties from whom Mr. E, namely the holder, has got right to recover. And then Mr. Z is known as acceptor for honor. Now, how acceptance for honor must be made is made clear as far as section 109 is concerned. So when the provisions regarding acceptance for honor will come into operation are dealt as far as section 108 is concerned. 109 deals with the cases where how acceptance honor must be made, and it says a person that is Mr. Z now, desiring to accept for honor must. So this is must is a statute mandatory provision. What he should do? A person desiring to accept for honor must, by writing on the bill under his hand. So it is required to be written by him under his hand. He has to write down on the bill. Declare, and what he has to do? He has to declare that he accepts under protest the protested bill for the honor of drawer or of a particular endorser whom he names, or generally for honor. So there can be acceptance on his part by writing on the bill under his hand. He has to himself write down, and what he has to do? He has to declare that he accepts. He has to make a declaration. And what is this declaration? That he accepts under protest the protested bill for honor of a drawer. So he can accept it for the honor of the drawer, or of a particular endorser, because he can, there can be acceptance for honor for any one of the prior parties. So he can say, well, I accept it for the honor of C, I accept it for the honor of B accordingly. He endorser whom he names, or generally it may be for generally for honor. So this is, and then section 110, acceptance not specifying for whose honor it is made. Now there may be a case where the acceptor for honor, it says, where the acceptance does not express for whose honor it is made, it shall be deemed to be made for the honor of the drawer. Ultimately, naturally, in case of a bill of exchange, as we know, that when it is not accepted by the drawee, his liability won't start, and hence he won't be liable. But who is liable in that case? It is drawer who is liable. So now, where the acceptance does not express for whose honor it is made, when it does not make mention as to for whose honor it is, who he has accepted it for whose honor, then naturally it shall be deemed to be made for the honor of the drawer, as far as section 110 is concerned. And then section 111 speaks about liability of acceptor for honor. Now Z has become an acceptor for honor. He may accept it for the honor of a drawer, or he may accept for the honor of any one of the prior parties. How? When we have dealt as far as section 108, 109 and 110 are concerned. And now as far as his liability is concerned, is dealt by section 111, which says an acceptor for honor binds himself. So he binds, once he has accepted it for the honor, he binds himself to all parties subsequent to the party for whose honor he accepts to pay the amount of the bill if the drawee does not. So now what is that? What is the undertaking which is given by him? he undertakes, and the acceptor for honor binds himself. So he binds himself to all parties subsequent to the party. So he shall be liable to subsequent party for whose honor he accepts to pay the amount of the bill if the drawee does not. So if the drawee does not, then only he will come into the picture, otherwise not. But then he is liable to whom? He is liable to all subsequent parties from the person or for the person for whose honor he has accepted. So if he has accepted for the honor of Mr. C, as we have dealt, he can make mention for whose honor he has accepted. So if he makes mention that it is accepted for the honor of C, he is liable. And so who are the subsequent parties? D and E are the subsequent parties. So he is liable to those parties accordingly. And such party and all prior parties are liable in their respective capacity to compensate the acceptor for honor for all loss or damage sustained by him in consequence of such acceptance. And then once he has become an acceptor for honor, then such party, namely the party for whose honor he has accepted, and all prior parties are liable in their respective capacities. So these prior parties, if they are liable in their respective capacities to compensate the acceptor. So acceptor for honor must be compensated for all loss or damage sustained by him in consequence of such acceptance. So now once he has become an acceptor, whatever is required to be paid by him, or whatever loss or damage is sustained by him, all parties which are prior parties are liable in their respective capacities to compensate the acceptor for honor. But the next part of the same section makes it clear. But an acceptor for honor is not liable to the holder of the bill. He is not liable to the holder of the bill. Though Z has become acceptor for honor, he is not liable to the holder of the bill, namely Mr. E, unless it is presented or in case the address given by such acceptor on the bill is a place other than the place where the bill is made payable, forwarded for presentment. So not later than day next after the day of its maturity. So when acceptor for he becomes liable, he is section says, but an acceptor for honor is not liable to the holder of the bill unless it is presented. The bill is required to be presented, or in a case the address given by such acceptor on the bill is at the place other than the place where the bill is made payable, forwarded for presentment, not later than the next day after the day of its maturity. The bill is required to be presented after, next day after the day of its maturity. And then only he becomes liable as far as section 111 is concerned. Now, when acceptor for honor may be charged, and for that you have to refer to section 112, which says an acceptor for honor cannot be charged. So he can be charged, you can proceed, the holder can proceed against him, but it says an acceptor for honor cannot be charged unless the bill at its maturity been presented to the drawee for payment and has been dishonored by him and noted and protested for such dishonor. So Z has become acceptor for honor. That does not mean he directly becomes liable, certainly not. What is required? An acceptor honor cannot be charged. You cannot proceed against acceptor for honor unless the bill has its maturity. So when the bill becomes mature, it has at its maturity been presented to the bill, it is required to be presented to the drawee for payment and has been dishonored by him. If it is, accepted, if it is honored by the drawee, that is the end of it. But if it is not, then naturally, if it is dishonored by him, and then when it is noted and protested for such dishonor, then only acceptor for honor may be charged as far as section 112 is concerned. This chapter deals with the provisions as far as acceptor for honor is concerned. Who can become an acceptor on honor, or what do you mean by acceptance for honor, is dealt right from section 108 up to section 112. With this now, section 113 deals with payment for honor, and it says, when a bill of exchange has been noted or protested for non-payment, so it has been noted and protested for non-payment. Any person, naturally, what is the result? Once it has been noted and protested for non-payment, naturally the person who wants to get amount will go to the court of law and file a suit. So this will harm the reputation of drawer and all the prior parties from whom he wants to recover the amount or against whom he has filed a suit in a court of law. And that we have dealt. Holder has got right to recover amount from any one of the prior parties. So now, when the bill of exchange has been noted or protested for non-payment, any person may pay the same. So any person, he may be liable or he may not be liable. Any person may pay the same for the honor of any party liable to pay the same. So any person may pay the same for the honor of any party liable to pay the same, provided that the person so paying, the person who now Mr. X wants to become, he wants to carry out payment for honor. So in that case, what he has to do, provided that the person, Mr. X so paying, or his agent in that behalf, it can be by him or his agent also, has previously, what he has to do, has previously declared before a notary public the party for whose honor he pays, and that such declaration has been recorded by such notary public. So it's not that he will directly go and pay. No. What he will do, he will, such a person who wants to pay for the honor of some person, what he will have to do, the so paying, or he may or his agent may, what they have to do, has previously, he has to go to the approach the notary public and declare before a notary public the party for whose honor he pays, and that such a declaration has been recorded by such notary public. So this is required to be recorded by the notary public. Then only Mr. X can pay for the honor of any party as far as section 113 is concerned. This is payment for honor. Who can be, as a person can be, person can accept it for the honor when he is not already liable. But here any person, he may be liable or he may not be liable, but what he has to do, he has to declare before notary public, and that such a declaration is required to be recorded by such a notary public, and he has to make mention for whose honor he is going to carry out the payment as far as section 113 is concerned. Section 114. What are his rights when somebody has paid it for the honor of somebody? What are the rights as far as such a person who has carried out payment for the honor is concerned, namely Mr. X? And section 114 says, any person so paying is entitled to all the rights in respect of the bill of the holder at the time of such payment, and may recover from the party for whose honor he pays all sums so paid, with interest thereon and with all expenses properly incurred in making such payment. So he once X has paid for the honor of party, then any person so paying, he is entitled to all rights. He is entitled to all rights in respect of the bill. He is entitled to all the rights in respect of the bill of the holder. So holder at the time of such payment, and may recur from the party for whose honor. So he can recur it from the party for whose honor he pays all the sums so paid, with interest thereon, and with all expenses properly incurred in making such payment. With this, section 115 deals with drawee in case of need, and says, where a drawee in case of need is named in a bill of exchange or in any endorsement thereon, the bill is not dishonored until it has been dishonored by such a drawee. So first step, proceed, go to drawee. Second, proceed to drawee in case of need. And unless when name of a person has been mentioned as a drawee in case of need, then it's section 115 says, where a drawee in case of need is named in a bill of exchange or in any endorsement thereon, the bill is not dishonored until it has been dishonored by such drawee, as far as section 115 is concerned. And the last section, as far as this chapter is concerned, is section 116, which deals with acceptance and payment without protest. And it says, a drawee in case of need may accept. So this is only applicable to drawee in case of need. It says a drawee in case of need may accept and pay the bill of exchange without previous protest. So drawee in case of need only can accept or pay the bill of exchange without previous protest, as far as section 116 is concerned. With this now, section 117 deals with compensation, with which we have dealt in the past. Now we come to chapter 13, dealing with what? Special rules of evidence. Now section when a party wants to file suit in a court of law, generally the plaintiff who goes to the court of law, who asserts a particular fact, the burden of proof is on him. But in order to make his task easy of recovering the amount by going to the court of law and to lessen the burden, legislature thought of making provisions regarding what? Presumptions as to negotiable instrument. And until the contrary is proved, and who is going to prove? So here it is not for the plaintiff. The presumption, it will be taken for granted as far as section 118 is concerned in favor of plaintiff, unless until the contrary is proved. So it is for the defendant to prove the contrary. Then if it is not proved by the defendant, then the following presumptions shall be made. And which are these presumptions? 1. A, small a, section 118 talks about of consideration, and it says that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. In case of a contract, this is a contract where consideration is must, otherwise that becomes void. But then in case of a negotiable instrument, there is a presumption with as far as the consideration is concerned. B deals with as to date, and it says that every negotiable instrument bearing a date was made or drawn on such date. So that is as far as second presumption is concerned. So when there is a doubt as to which is the day on which this was drawn, because that will be for the purpose of calculating the maturity, and hence as to date it says that every negotiable instrument bearing date was made or drawn on such date. Subclause C as to time of acceptance, and it says that every accepted bill of exchange was accepted within a reasonable time after its dates and before its maturity. So that is a presumption. As to time of transfer, it says that every transfer of a negotiable instrument was made before its maturity as far as small d is concerned. Small e as to order of endorsement, It says that the endorsement appearing upon a negotiable instrument were made in order in which they appear thereon. So the order, first of all, B has passed it on to Mr. C, endorsement by B, then endorsement by C, then endorsement by D accordingly. So this is an order of endorsement. Why it is necessary? Because the party can proceed. I mean, when you talk about rights and liabilities of the intermediate party, the intermediate party has got right to recover amount from prior party and is liable to the subsequent parties accordingly. So that must be made known, and hence as to order of endorsement. Next, small f deals with as to stamps, and it says that a lost promissory note or lost bill of exchange or check was duly stamped. Now, in case of a check, the stamp, the question of stamp doesn't arise, but that is applicable as far as say a lost promissory note and bill of exchange. That a lost promissory note or bill of exchange was duly stamped. And lastly, G says, small g says, very important. It says that a holder is a holder in due course, and it says that the holder of a negotiable instrument is holder in due course. But this is subject to proviso. And what is that? Provided that where the instrument has been obtained from its lawful owner or from any person in lawful custody thereof by means of an offence or fraud, or has been obtained from the maker or acceptor thereof by means of an offence or fraud, or for unlawful consideration, the burden of proving that the holder is a holder in due course lies upon him. So, I mean, this is the part with which we have dealt at the time of discussing the concept of holder in due course as defined by section 9. So, this is required to be proved by the holder in due course, otherwise not. Otherwise it is not at all, because this is subject to proviso, otherwise not. With this now, section 119 as far as this chapter is concerned deals with presumptions on proof of protest, and it says, in a suit upon an instrument which has been dishonored, the court shall, on the proof of protest, presume the fact of dishonor unless and until such fact is disproved. Now, what is protest? That we have dealt now in detail. So, in case of presumption on proof of protest, what is the presumption? In a suit upon an instrument which has been dishonored, the court shall, on the proof of the protest, presume the fact of dishonor unless and until such fact is disproved. Section 120, 121 and 121, they lay down, I mean, this is what is known as the principle of estoppel. And what is this principle of estoppel or doctrine of estoppel which is applicable? For that, if you remember, I told you in the past that you can refer to the provisions right from section to know the details as far as the estoppel is concerned. I mean, if you do or say something at a particular point of time, then you cannot, I mean, deny that. You are stopped from denying that is the principle. And section 120, you can refer to the provisions as I was telling you, refer to the provisions as far as Indian Evidence Act is concerned, right from section 115 up to section 117 of the Indian Evidence Act. And what is this section 102? It says, no maker of a promissory note and no drawer of a bill of exchange or check and no acceptor of a bill of exchange for honor of the drawer shall, in a suit thereon by a holder in due course, be permitted to deny the validity of the instrument as originally made or drawn. So he is estopped, he is not allowed accordingly. 121, estoppel against denying capacity of payee to endorse, and it says, no maker of a promissory note and no acceptor of a bill of exchange payable to order shall, in a suit thereon by a holder in due course, be permitted to deny the payee's capacity at the rate of the note of bill to endorse the same. So that is as far as section 121 is concerned. 122 deals with estoppel against denying signature or capacity of prior party, and it says, no endorser of a negotiable instrument shall, in a suit thereon by a subsequent holder, be permitted to deny the signature or capacity to contract of any prior party to the instrument. With this now, as we want to proceed to next chapter, namely chapter 14, which deals with cross check right from section 123 up to 131 of the Negotiable Instrument Act. We have to first of all proceed to section 6, and then once we finish with that, this is also the time for us to start discussing right from section 138 up to 147 of the Negotiable Instrument Act, which deals with what? Criminal liability in case of dishonor of certain checks. We have to, we shall be dealing with that, and then some of the sections where there is a reference as far as section 6 is concerned, to which we shall be referring during course of our lectures.